Hello and welcome to Outside Views EU, where we dissect the latest developments in European politics and policies. Today we're diving into a legal dispute that highlights the lingering complexities of Brexit and its aftermath. The European Commission has referred the United Kingdom to the Court of Justice of the European Union for failing to terminate certain bilateral investment treaties or BITs with 6 EU member states. And if you thought Brexit was the end of the UK's entanglement with EU law, think again. But let's start with some background. Bilateral investment treaties are agreements between two countries designed to protect and promote foreign investment. They provide guarantees like fair treatment for investors and protection against expropriation. In theory, they sound great. After all, who wouldn't want secure investments? But in practice, BITs between EU member states, referred to as intra-EU BITs, have long been a contentious issue. The European Commission has held a firm position that intra-EU BITs conflict with EU law. The crux of the problem lies in investor-to-state dispute settlement mechanisms often included in these treaties. And these mechanisms allow private investors to bypass domestic courts and take disputes directly to arbitration panels. Sounds efficient, right? Well, the EU sees it differently. The issue came to a head in 2018 with the Achmea judgment, a landmark ruling by the ECJ or the CJEU, however you want it. In this case, the court declared that investor-to-state arbitration under intra-EU BITs is incompatible with EU law. And why? Because it undermines the principle of mutual trust between EU member states and the autonomy of EU law. In other words, allowing private arbitration sidesteps the legal frameworks that's supposed to bind all EU countries together. Following the Achmea ruling, all EU member states, including the UK at the time, agreed to terminate their intra-EU BITs. This was formalized in 2019 through coordinated declarations and later a plurilateral treaty in 2020. The UK, however, chose not to sign the treaty after its departure from the EU and also failed to bilaterally terminate its BATs with 6 member states: Bulgaria, Czechia, Croatia, Lithuania, Poland and Slovenia. And now, here's where the things get tricky. The BITs were concluded while the UK was still a member state, making them intra-EU agreements under EU law. According to the Commission, maintaining these treaties is a clear violation of EU law as established in the Achmea judgment. Despite repeated warnings, starting with a formal notice in May 2020 and followed by a reasoned opinion in October 2020, the UK has not taken action to terminate these treaties. So what happens now? The Commission has referred the matter to the court, exercising its authority under Article 7 of the withdrawal agreement. And this article allows the Commission to pursue legal action against the UK for breaches of EU law that occurred before the end of the Brexit transition period. The Commission has until December 31st to bring such cases to the ECJ. In this case, the Commission argues that the UK's inaction is not just a technical oversight, but a breach of its obligations under both EU law and the withdrawal agreement. So let's take a moment to unpack the implications of this referral. First, it underscores the enduring influence of EU law on the UK, even post-Brexit. While the UK is no longer an EU member state, its past commitments and the legal framework established under the withdrawal agreement mean it's not entirely free of EU oversight, at least not yet. And this is a stark reminder that disentangling decades of integration is far from straightforward. Second, this case has broader implications for international investment and trade. BITs are designed to create a stable environment for investors, but the EU's position challenges the very mechanisms that underpin these treaties. By opposing investor-to-state arbitration, the EU is sending a clear message. disputes involving member states should be resolved within the EU's legal framework, not through external arbitration panels. And this stance could influence how future investment agreements are structured, both within and beyond the EU. Third, the case raises questions about the UK's international credibility. By failing to address this issue, the UK risks being perceived as a state that does not honour its commitments once more, and this could have ripple effects on its post-Brexit ambitions to negotiate new trade and investment agreements. Of course, there are counter-arguments to consider. The UK might argue that its decision not to terminate the BITs reflects a commitment to protecting investor rights, particularly in a time of global economic uncertainty. Moreover, critics of the Commission's approach could argue that the EU is overreaching by enforcing its legal interpretations on a non-member state. However, the fact remains that the UK agreed to the ACMEA principles and the coordinated termination of intra-EU BITs before Brexit. Its current inaction appears to be a breach of those prior commitments. Whether this is a calculated political move or simply an oversight, it is a situation that has now escalated to the highest levels of European scrutiny. So what's next? If the ECJ rules against the UK, it could face legal and financial consequences, including potential damages to investors who find themselves caught in this legal limbo. More importantly, this case will set a precedent for how the EU enforces its legal framework on past commitments by former member states. It's a legal drama with high stakes, not just for the UK, but for the EU's credibility in managing post-Brexit disputes. But what do you think? Is the EU right to pursue this case, or is it holding the UK to an overly strict interpretation of its obligations? And how do you think this will impact the broader relationship between the UK and the EU? I'm quite curious, so please let me know your thoughts in the comments below the video. And don't forget to like, subscribe and hit the bell for more deep dives into EU policies and their global implications. Thank you for watching Outside Views EU, and I'll see you in the next video. One of them is right here in the end screen.